I should like Snuggies instead as a comfort blanket. Instead, I like Lorraine Schwartz, which is a problem.
The rings, the
What?
mixing of...
Sorry, we're not serious today. For me, wardrobe is always the way that I enter a character. I'm a very shy person. So if I look a certain way, then I can escape into that. Like and stuff today, I don't dress like this in real life, but like I'm having to like do interviews and talk. So I'm going to wear like a crazy pattern, really crazy rings. Also are like my comfort blanket. It's just a very expensive comfort blanket.
Hi besties, it is Katie Joy. Welcome back to my channel. I know it's been a minute since we talked about Blake Lively. Listen, we are still in discovery, and because discovery disputes are so common, it got a little bit overwhelming this week. I'm not going to lie. There was like a response to the motion for sanctions. There was an opposition to Jed Wallace's motion to dismiss. There was a motion to compel for Jed Wallace and then a supplemental. And a lot of this is just your average of the day, run-of-the-mill discovery stuff and motion to dismiss. And I started to realize that every single filing maybe doesn't need its own video and not everything is super, super important, because then sometimes y'all get a little bit upset if rulings don't go in the way of Wayfair. And I realized that there's a couple things that happened this week that were not great for Blake. And that was one, when she sought discovery from Wayfair and did an omnibus motion to compel, Wayfair responded by basically saying, you know, most of what she's asking for is we're already going to send her. So much of this motion to compel is already moot and it's not even necessary. And then Blake sent the supplemental list of all of these documents that she had wanted that she said she wanted till today's current date, which is almost 9 months after she filed this lawsuit to begin with. And Wayfair was pushing back and saying, you know, they don't really feel comfortable sending all of that information. And if she is going to extend the date, then we should get discovery from her until that date. They didn't really respond and provide an argument about why Blake Lively should send that. And so it wasn't really the best argument to make, right? But the judge did give them a small victory when it comes to this. Basically, what the judge said in the order for the omnibus motion to compel is that, listen, Blake, they were already going to send all of this to begin with, okay? And you are a little bit premature here. And so, yes, they will send this to you. And he just like kind of finalized it and said, you have to X date to send her over these documents. And then he went on to the aspect of whether or not he was going to allow Blake Lively access to all of Wayfair's records until the present date. And in that case, he didn't agree with her. In fact, he said if he was going to look at the scope of the litigation here, anything that's happening today would be way too far removed from the claims and arguments that she made in her initial complaint. Because now anything that Wayfair is really doing today isn't a smear campaign. Instead, what they're doing is defending active litigation. And so he's not going to allow her to entertain this. He's not going to entertain this idea that anything that the Wayfair does today in response to this active case is actually a smear campaign. So I did like in that respect that he kind of put a deadline on what he would consider. And that deadline is in February, okay? What he wrote in the order is, that brings the court to the second question. Through what dates are these materials discoverable? Lively seeks discovery through the present. That is for the approximately 9 months since she filed the CRD complaint, which is for 646 at 6-9. The Wayfair parties respond that if an extended discovery is permissible, the cutoff date should be February 18th, when Lively filed her amended complaint based on considerations of relevance, overbreadth, and proportionality, the court deems that the Wayfair's proposed cutoff date is more appropriate. Although, as previously explained, the materials detailed above are relevant to her claims, their relevance diminishes over time with greater distance from the underlying allegations in the complaint. Moreover, the further in time the documents are from the allegations in the complaint, the more likely they are to pertain to this litigation itself. Simply put, Lively's allegations of ongoing harm justify certain extensions of discovery window, but without more, they cannot justify perpetual discovery, especially given the potential that her allegations regarding a smear campaign overlap with advocacy relating to an underlying suit. So the judge is telling Lively that he will allow her until February 18th claim that the ongoing smear campaign existed. Okay. And that's the cut. That's the firm date. So if she wants documents, she can only have until February 18 because after that, and after she filed her amended complaint, at that point, everything that the Wayfair parties are doing is simply defending and advocating in the public. And so if Brian Friedman is speaking about his clients, he's advocating and defending his clients. And attorneys are allowed to be zealous advocates and defend their clients in the public, especially if press becomes negative that could impede and create issues with the jury. He writes, requiring the Wayfair parties to produce documents for the last 9 months would not only be burdensome, but likely sweep in extraneous materials outside of the core allegations in the suit. Each of the parties is accordingly ordered to provide responses to the enumerated RFPs through February 18th, except as otherwise noted. And then they should be required to provide a privilege log with respect to documents post-dating Lively's complaint. So if there's any comments or if there's any communications that they're having with their attorneys, they can use a privilege log, which means she doesn't get access to them. And then another detail that I think is important to mention is that when it comes to the other HR complaints that she's demanding, basically what the judge told her was that, listen, if you want access to other complaints that have been made in this case against Wayfair or any of their employees, the only kinds of reports you can have is only if Wayfair, Jamie Heath, or Justin Baldoni had other people accuse them of sexual harassment and discrimination. But if there was other forms of discrimination that have nothing to do with your case, you do not get any of those complaints. We do know that there was a feud with them at one point about discrimination. I think it was related to race, which ended up not going anywhere. It was dropped. The case was dismissed. And so if there's no other complaints related to HR related to sexual harassment, basically they have to send over if they have other ones, but if they don't and it's none, then she gets none. And then when it comes to trying to use Brian Friedman as an agent of the Wayfair parties versus a lawyer, he didn't buy that. And he again declined to make them hand over any more documents to her and instead told her, listen, if you're looking for stuff from the law firm, ask Wayfair if they have the client file. And if they have the client file, they can give you other stuff from the firm that may or may not be privileged. So really what I like about this ruling is that there's no longer an ongoing smear campaign if anyone talks about Blake today. So if you or I are on the internet and we speak about Blake and we form an opinion that's not positive of her, the judge would tell her that that's not a smear campaign. They are responding to active litigation and discussing a case in the federal court. Okay. And so it kind of makes me wonder if subpoenas seeking documents to present from content creators could possibly get limited significantly, given that the judge says that content creators discussing the case now, I mean, how would we then be part of a smear campaign if it's in August 29th and she filed her case in December of 24, right? It's very far removed. So I did like that. And I also think that this isn't really like a loss for them because discovery disputes are so normal, and it gives a hard cutoff date where Lively can no longer claim a smear campaign is happening in August of 25. Okay. Now, the second issue I wanted to talk to you guys about was related to Mr. Perez HIlton. Now, I guess Perez was in court yesterday in Nevada, and apparently my subs and followers over on Instagram were leaving some comments, and they just said that like Perez looked so upset coming out or kind of defeated, and the hearing was deferred. And I don't know the whole details of what happened. You might have to go check his page about what happened in court in Nevada. But I will say that Lyman actually didn't buy Miss Lively's argument that he had waived his personal jurisdiction, and that because he had filed a issue regarding the subpoena and he was seeking a protective order regarding a subpoena, she was trying to say, well, he has waived personal jurisdiction and he has made himself he's availing himself to jurisdiction here by filing in this court. And that would be kind of no different than Jed Wallace and trying to use that argument with Jed Wallace, because Jed Wallace is responding to her, even though Jed had a case dismissed for jurisdiction, and he has a second motion to dismiss pending related to jurisdiction as well. Okay. Well, the judge rightfully ordered that he holds no jurisdiction over Mr. Perez HIlton. And Perez is one of a couple large creators that have been targeted by Blake. Yesterday, Megyn Kelly notified her audience that she actually became a target of Blake as well. And despite Blake's effort to gain access to any of the contacts that Megyn Kelly had through her podcast on YouTube and other platforms, she did not at all get anything from Megyn. And Megyn had a pretty serious response to Blake in that, first of all, she would never give up anything related to her confidential sources. She is a member of the press that's indisputed. I mean, Megyn worked for NBC and Fox News. Like, she is a certified journalist, and to try to claim that she's not would be ridiculous, and Blake would never be able to overcome that. And she also noted that she came to her opinion on the situation herself after going through all of the court cases, the documents, and reviewing them against the evidence, and some of the claims started falling apart. And Megyn noted that when she started the case, she was neutral. She had no opinion on whether or not Baldoni was guilty or Blake was, honest or lying. And that through her own experience of one being a lawyer and then also being a journalist for, 30 years total of experience here, she said that she didn't believe Blake's claims. And she formed that opinion solely on herself. And it had nothing to do with the fact that Brian Friedman was her lawyer years ago, prior to him ever knowing Justin Baldoni. So Megyn Kelly was also targeted. And it kind of makes me wonder if Billy Bush was as well, because Billy Bush had been mentioned in court filings and in RFPs. And I don't know if he has made any comments about that at all. But Megyn says that she got nothing. Blake got nothing from her. So when it comes to Perez, it begs the question that if she's getting nothing from Megyn Kelly, and we still don't know what's going on with Candace Owens, and the ongoing motion to quash is still pending for Andy Signor, Popcorn Planet. So right now, really, Perez is this only like curveball that's left. But when it comes to the courts in the state of New York, Lyman says he has no jurisdiction over him, meaning in his court, he cannot make him, Perez, comply with discovery and force him to hand over documents because he has no jurisdiction over him. And he says Lively has not alleged that the discovery she seeks from him relates to his contacts with the forum state. Rather, she asserts that he has either consented to personal jurisdiction in the court or waived any objections to the contrary. And he says that Perez has repeatedly indicated that he does not consent to personal jurisdiction in this court. And he writes, Lively cites 3 of his filings as evidence of his submission to this court's jurisdiction. In the first 2, he seeks sealing and redaction of his personally identifying information, as with requests for continuances or stays, although these filings do to some extent seek affirmative relief from the court, they do not demonstrate an expectation of litigating either the merits of the subpoena or any other substantive issues in the case. A person can ask that his personal information not be publicly disclosed by the court without generally subjecting himself to the jurisdiction of the court. These filings, therefore, do not constitute waiver of personal jurisdiction. And then she also claims a motion for a protective order was a waiver, but he didn't agree with that either, because the only relief it is seeking is preventing Lively from issuing additional subpoenas. The judge also ordered and opined that his subsequent filings addressing the merits of the subpoena did not operate as a waiver. His arguments on the merits have therefore been made as an alternative to his personal jurisdiction defense. As courts have explained, individuals may simultaneously raise both personal jurisdiction and substantive arguments for they should not be required to either forfeit a defense of the position of the merits or waive their due process rights. So he took in account that Perez is a pro se litigant, and ultimately he said the court is reluctant to hold that Perez's motion operated as a waiver of his rights given his lack of representation and his clear intent to litigate issues related to the subpoena in the District of Nevada. The court accordingly holds that it lacks personal jurisdiction over Perez with respect to the subpoena, and Lively's motion to compel is thus denied without prejudice for lack of personal jurisdiction. So this is a solid order. Some people got upset because they said, well, now it's without prejudice. Well, what he's saying is that it's not in his court, it's dead because he has no jurisdiction over Perez. So if she wants to bring these issues, she has to bring the issues in the proper court, which is in Nevada. And he won't allow a transfer because he has zero jurisdiction over Perez. And the subpoena very clearly states that compliance is due in Las Vegas. And so because he is seeking a motion to quash in Las Vegas, that's the proper forum. So she certainly can bring the motion to compel there. I don't know if she will, though. I have no idea. And then Perez wins in New York. And so basically it'll get kicked to Nevada, where that judge deferred a ruling because of what was going on here. And so he has another hearing set for the 2nd to discuss the issues at hand and whether or not they're going to quash the subpoena or not. And in Nevada, he is arguing that he is a journalist and that he has reporter's privilege. So this is dead in New York. It'll be in Nevada, and Nevada has really strong press privilege or reporter's privilege. So I think he'll do okay in Nevada. And I know that Perez was happy about that. So her attempt to get waiver of the jurisdiction did not work. And you know what I mean? I'm going to say something. I think that when it comes to Jed Wallace's second amended motion to dismiss, I don't think that the judge is going to find that Lively has, or the court still has jurisdiction over him here. I don't think she met the burden, and I expect that complaint to also get dismissed against Jed. And in her motion to dismiss, she asked the court to, if they're going to dismiss it on lack of jurisdiction, then sever him from the case and transfer it to Texas. It all just seems ridiculous. She should have just transferred it to begin with. But I guess by doing it this way, she's enabling and allowing herself, to harass him a little bit longer, even though she has nothing against Wallace. So even though she's had a few wins this week in discovery, she's also had some pretty significant losses. And that's what happens during discovery. And even though, Wayfair had some pretty significant losses where they have to hand over some documents, they've also had some wins where we have finally decided that there is no smear campaign after February 18th. So I think overall, she is being reined in. She's being given like a boundary and a leash, and the judge is not going to further entertain any conversations about ongoing smear campaigns. And I think this could directly impact Perez and any of the other content creators if she is seeking documents beyond February. So tell me what your thoughts are. Do you think that the case is treading poorly, or is it bad, or is this a good ruling? What are your thoughts? Let me know in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.